Morning,
Good morning. Can I have you state your name and date of birth, please, for the record?
Monica White, 9984.
So, Ms. White, I'm just piecing together, it looks like what's going on. It looks like you're on a stay from January 21st, 2023.
What does that mean?
A stay was an agreement that you entered into that you had to complete some conditions, and if you completed those conditions, your case would be dismissed. Do you not recall entering that
Yes.
agreement? Okay.
Okay.
So it looks like we did not have the conditions of the stay met. Specifically, you didn't do any work crew, it looks like, at least for a period of time. There was a theft class that you were supposed to attend. It also looks like there's an allegation of another theft that's taken place in the city of Vancouver now. So my assumption of what we're going to do is very likely have a notice filed by the city attorney's office to revoke your stay and to enter a conviction for the theft in the third-degree charge. Ms. Carmi, I'm assuming we're not ready for that proceeding today, but would schedule her out a week or two for that.
Correct, and we will file the document and get her reappointed.
Okay, so original attorney, it looks like, was Ms. Ward on the matter. So assigned Mr. Wallace. Okay.
Could I get their information?
Excuse me?
Could I get their information?
Oh, yeah.
Okay.
Yeah, we're going to assign the attorney and I'm going to explain how you're going to get in contact with him.
Okay,
I'm going to set the case out a couple weeks so you can talk to him before the next court date.
thank you. I appreciate that.
Yeah,
Good.
but we need to have you coming back to court.
Huh?
We need to have you return to court when
Yeah,
you're supposed to, because that didn't happen.
Right,
For
I-
over a year, you were gone.
Yeah.
And then you only came back because you got a new charge. So we can't have,
Oh, actually, I was in the process. I had moved and I paid
don't
off.
say anything else.
Oh, I'm sorry.
Madam Clerks, if you can provide me a couple of Mr. Wallace options for July to set this to. Okay. Let's set this out to the July. Let's set it out to July 17th. And that appearance is going to be Ms. White at 10 a.m. that day.
Thank you.
At 10 a.m. Yeah, July 17th at 10 a.m. I'm going to release you on your recognizance, Ms. White. We're going to get you some paperwork at the desk by the door. Once you get your paperwork, the same place you checked in for court where the glass partition is, there's a table on the left-hand side. Get a business card for Kenneth Wallace. Call his office tomorrow. Let him know you've been assigned as his client, okay? Thank you, ma'am.
Thank you, sir.
Yep.
Have a good rest of the day.
Thank you.
Your Honor, all.
Okay, Cammie Pearson, come on up.
So, Your Honor, I think we're going to take a little bit of a different change of course today, and I can explain to the court. I've had some lengthy conversations with the prosecutor. What we're prepared to do today is admit to the failure of DUIs with explanation. We then have a plan going forward that I can lay out to the court that I think will alleviate both the court's concerns and get us to where we need to be, which is really into a treatment scenario here in short order. But we do not need the evidentiary hearing. I believe she is prepared to admit today, again, with the explanations as to why.
Mr. Licio Laghi, we're going to go ahead and release you then, sir. Thank you for your time and your attendance today.
Thank you, Your Honor.
Thank you.
Thank you.
And is the warrants that she has on the 2021 cases, are those new warrants? On the Woodland cases?
Let me just look real quick.
All right, so those are warrants that we've had. Okay.
Oh,
Okay. So go ahead, Mr. Cheney. I'm gonna listen and figure out what's proposed.
So-
It feels like we're kind of going in a circle here.
Well, we made some progress. So first of all, as I mentioned at the last court hearing 2 weeks ago, she was told by Columbia River Mental Health that she was being evaluated for deferred prosecution, then they refused to write the deferred prosecution letter. I talked to senior management, policy level management, I think a assistant VP there. They do, and this is a quote, they do deferred prosecution evaluations, but do not write the letter for the purposes of entering it into court under 1005. That is, as you can imagine, my conversation may have flowed from there. Which
Are they
didn't make any
are they
sense.
state certified though? I've
Uh,
never been aware of Columbia River Mental Health doing deferred prosecution.
No, and that was why that was my point to them, was just we wasted so much time because she's in active treatment at Columbia River Mental Health. They should have never told her because she did everything she could, because they told her and told me that they do deferred prosecution evaluations, but they actually don't, because as we know, without that letter, it's as if the evaluation never existed.
Yes, no,
And I had that conversation with senior management, but what I'm suggesting is it's not her fault. So in the meantime, she now has a lifeline deferred prosecution evaluation. Because she is already at Columbia River Mental Health for treatment, she has an inpatient bed date lined up there. I would very much like to get her to that inpatient. It is, the bed date is in about a week and a half to 2 weeks. My suggestion for the court, and what she wants to do, is make it to that. I would also add that now there's additional health complications that I think would behoove her to be an inpatient as fast as possible. What we would like to do with the court's permission is set a review in 2 weeks. That way, between now and then, she's already got the lifeline evaluation scheduled. Then either she provides in 2 weeks proof that she is checked into inpatient treatment, and we will reset with a FTA from that date, or I've explained to her would likely happen if we don't have that paperwork is a warrant would immediately go out for her arrest. But I think that I really want her to get to that inpatient date, because I think that will help her enormously, both with clearing old warrants, getting this case moving. Again, not her fault that I was told there was a deferred prosecution evaluation and then that they wouldn't. And she's done everything she can to get that squared away with a new assessment to be done at Lifeline.
So this whole process began 45 days ago, back on the 15th of May. And at that point, the allegation in front of the court was that someone who had been on release conditions since February, had been on release conditions, the incident was in February, but had been on release conditions with this court since January of 2025, had not participated in pretrial release at all in terms of showing up for anything. So on one hand, yes, there is some benefit certainly that she's going to be accessing a inpatient program, but the court is profoundly concerned that for 5 months you've had no supervision and clearly have been continuing to access substances to the point where you need to have inpatient treatment now. And so, a bit baffled. So I'm assuming that because this has been pending and set over and so forth, she's never re-engaged and done a UA or anything like that. Or
Well,
am I completely off center on this?
So what the documents that were provided by the prosecutor from 2Watch, what they showed was very good check-in compliance. I mean, there was a few misses, but fairly good check-in compliance for February, March, and into about early to mid-April. After that, the check-in became spotty. The explanation there is that she was not using her own phone. She was using her mother's phone. I don't know if that may have explained part of the problem in the month of February, mid-April-ish to February. Since then, she's taking screenshots every day of her call-ins and check-ins for them. So
But
that is the.
is she submitting UAs though? Because
Well, I
when
think she's-
when the violation was filed in April, she'd missed the UAs in February, the UAs in March, and the UAs in April. And it says on the violation, she has failed to submit to any UAs since being granted pretrial release. So she can check in all she wants, but there's no community safety barriers on her if she continues to be able to use because she never shows up for her UAs.
I can only say what the paperwork says, which is it's showing that she's at least trying to check in.
But the purpose of pretrial release is to maybe if it's just to get her to court, she's got active warrants on her other cases, so I can't give her credit for that. But the primary issue was that she was showing up, and I gave her a ton of credit for it. She had a 2023 case. She showed up in 2025. She made her court date. But because it was a drug case, I said, you have to do random UAs, and she never did a UA. She didn't do a UA in January, in February, in March, in April, in May, or in June. And clearly the information provided to the court today says that she has such a use issue that she's required to do inpatient treatment in the next 2 weeks. So I'm trying to choose my words carefully, but I don't think that she's really technically been supervised other than she calls when she's supposed to call. Ms. Pearson, I feel like I'm chastising your attorney. He's not the person I'm looking to chastise. Because you need to at some point understand what's going on. You were given probably one of the lowest levels of release for a person with multiple DUIs, and you've not done what I've told you to do, which was to call a call line and UA when you're supposed to. So this court has some knowledge of your substance use during the pendency of the case, which I have to believe in the fact that they have to escalate you up to an inpatient you've probably been using during the pendency of my case. That's circumstantial. That's not direct. Boy, ma'am, I wouldn't talk right now if I were you. You dig yourself into a deeper hole. So you have 2 weeks to get yourself an inpatient bed and an evaluation. I'm not giving you any more time. We've spun our wheels for a month here, and you've still been able to do whatever you choose, and you walk out of this court every time. Setting this to July 10th, 2025 at 10 a.m. You are on enhanced pretrial release, which is what I placed you on, administrative pretrial release, which I placed you on before. You are to call them today. If they have you UA, you are to show up and UA. I understand the strategy of calling this hearing today, ma'am, but I feel like this has been a substantial waste of the court's time. I don't know what else to say. So hopefully you can take some affirmative steps that make it look like you're actually going to be doing the things we're asking you to do. July 10th, 2025 at 10 a.m. Call pretrial release.
And if she shows the proof that she is in fact inpatient by that point, can that date be reset until it'll 30-day likely? I think it's
I
likely a
have
30.
never, in my 4 years on the bench, ever stood in the way of someone accessing treatment. I will bend over backwards if you're in an inpatient program.
Thank you.
Your Honor, we next call the matter of Megan Farah. Ms. Farah, come on up. And Madam Prosecutor.
Yes. Yes, and I need to sign it for you. Apologies.
The state contemplates 2 days of work through with substance abuse evaluation and any necessary treatment. I would note for the court that she is currently engaged in treatment services with Helping Wellness Professionals.